and I'll do a thing at the end.
Okay, ladies and Mark, ladies and gentlemen, welcome to a little technical difficulty here. All right. Wow. Sorry about that. All right. Welcome to the Sunshine Ordinance Task Force Complaint Committee special meeting, April 26, 2016. It is now 4:07. Mr. Young, can you call the first item? Call the roll first.
Member Wolf.
Present.
Wolf present. Member Pilpill.
Present.
Pilpill present. Chair Fisher.
Present.
Fisher present. We have a quorum. There are no agenda changes at this time. Item number 2, file number 15164, complaint filed by Anne Chabot against Howard Lazar and the Arts Commission for allegedly violating Administrative Code, Section 67.21 and 67.25 for failure to respond to a public records request in a timely and/or complete manner.
Motion to find jurisdiction.
Can I second that? Second.
Is there any public comment regarding jurisdiction?
Hearing none.
The motion to find jurisdiction passes without objection. Would the complainant like to make their presentation?
5 minutes, right?
Yes.
You will have 5 minutes.
Hello, you guys. This is one of those things where if I hadn't filed a complaint, this thing would have sat in the trash forever, and there would not have been a response at all. By filing a complaint, it triggers them to go and find out what's going on, what is this about, and so that's why I filed the complaint. Basically, this issue of the IDR sitting in Howard Lazar's trash can for a number of days is, it's just another one of those things, because it wasn't just my IDR that sat there. Tad Sky is 71 years old. He's one of the longest street artists, way before there was even a street artist program. He's now volunteering his time to run the lottery at Justin Herman Plaza because it's in chaos down there. So included in the trash was a notice of an advisory lottery meeting that they were going to have. So Tad Sky went down there thinking that there was going to be a lottery meeting, and Howard Lazar just didn't respond, didn't get the thing. So it's not just my IDR that wound up in the garbage, it's other stuff too. So in typical fashion, Kay Patterson seems to want to turn things around, or her response was really not responsive at all. Basically, this data dump thing that she often does of supplying duplicate documents, like November 16th, photos of November 14th, when she sends it 3 or 4 times, it jams up my email, it wastes paper, it wastes people's time, because you got to go through this and sift through it, and it's just annoying. I was at the State Court of Appeals this morning, and there was an interesting appellate case in a criminal matter where there was a discovery issue, and the time that it took and what they called data dumps to sift through these unorganized files was amazing. And it was an interesting case because I was thinking about this case tonight. So there are also other things, like she copied Aideen Vera of the city attorney's office. As of December 9, 2015, Aideen Vera had already left the office, and there was no city attorney of record for the Arts Commission. Howard Lazar's logbook of November 20th was unsigned, and this is something that really irks me to no end. I changed my name legally in 2013, yet for some reason, Kay Patterson continues to call me by my old name, which is very irksome. That's basically it. To me, it's a classic late IDR. I wouldn't have gotten the documents, of course, if I hadn't filed this complaint. And also in some logbooks that I got this morning that I went through, it seemed that as recently as this morning, street artists were complaining that the phone system of the Arts Commission is messed up. So, it's that usual lack of communication. Okay, that's it.
Thanks. So normally I'd ask if there was anyone to offer facts and evidence, but we don't have anyone, so come on up. We will now hear from the respondent for 5 minutes. Mr. Young? Okay.
Hi, good afternoon. Kate Patterson, San Francisco Arts Commission. So I don't really have any added detail aside from the letter we submitted basically explaining that the email did go to Howard's junk mail, and so he wasn't aware that it was there. We did also cite the fact that we have in the past, and it's something we've discussed here, had issues with Ms. Trabou's AOL account, which changed fairly often, and we had taken measures to ensure that email correspondence from her old AOL accounts were delivered to our inbox, but since this was a new one that we were not aware of, it went to the junk mail. So we did our best to deal with the situation, but we were unaware that it had changed. And since I'm just receiving this response letter from Mr. Trabou, I just want to address a couple items, even though none of these are relevant at all to this complaint, because once we were alerted to the email, we did respond, and we did respond fully. But I just want to refute the assertion that we would not have responded had she not filed a complaint. Also a simple email checking in on the status of a request is another very acceptable and cordial way of following up on an information request that is not a complaint filed with the Sunshine Task Force. So we would be very open to receiving that kind of communication. Also, she alleges that I was not in the office when her initial email was filed or sent, and I actually was in the office. I just checked my calendar. I was in the office the first week of December. The previous Thursday and Friday were the Thanksgiving holidays, so I was not in the office there, but nor were my coworkers for the most part. Also, Tad Sky is not here to represent himself, so I don't think there should be any credence attributed to number 3 on her list. And also, we provide the documents unless you tell me otherwise. I believe it is not our responsibility to organize it in a certain fashion. With emails, obviously, their chains can be long, and if we're providing documents from multiple senders that where those chains intersect, there could be duplicative documents, but really our goal is to be as thorough as possible. And again, we don't have the capacity to go through and organize it in a special way. Our goal is to just get the documents in as in an expedited fashion as possible. And so again, as I say in the letter, there's another email which Mr. Trabou is aware of, has used in the past, the records request email, which was established at the request of this body. So she could have also sent a copy. In fact, I would advise her to always CC that email when she is reaching out to other staff to ensure that I do get it and that I do see it. And if she changes her email to another AOL account, to maybe give us a heads up so that we can be sure to put the measures in place that ensure delivery to our inbox. Thanks.
Thank you. Do you have any questions? We're going to go this way
I have
first.
a
Member Wolf?
question for the Arts Commission. So, as I understand it, you were saying that there's a separate email that you've set up for public records explicitly, and then this request came to your own staff email.
It came to Howard Lazar's email.
Howard Lazar's email.
Yeah.
Now, what...
But it was delivered to his junk mail account.
Right. So my question is, are there different rules established on that public records email account to prevent anything from going to the junk email? Because in this case, you have someone who used a different AOL account, who's a known, someone who's requested documents in the past.
Sure.
But we could have a citizen who also happens to use an AOL account, who's never requested a document before. So I just want to ensure that there's, a search of the junk mail or the rules turned off on junk mail for that public records request email to ensure that requests don't go unnoticed.
Sure, I think that's a really good suggestion. I don't know, like off the top of my head, if there are separate rules for that email. So I'm happy to look into that.
You'll check.
Yeah, that's easy enough to check.
Right, and then the other procedure would just be to be constantly checking that junk mail on a regular basis. Not constantly, obviously, but regularly checking the junk mail if it's not possible to set up different rules to ensure
Sure.
things aren't filtered.
Sure. But again, I think if one has an AOL account, then, and especially since we've already established on the public record that we've had issues with the change of AOL accounts, and even Member Fisher, who has a background in this kind of thing, did say that like the number one email that get delivered to junk mail often are AOL accounts. It would be very helpful, either a phone call or, some sort of outreach that alerts us to the change in account would be very helpful.
Does your website's page where it describes how to submit a public records request advise users that you've had problems with AOL accounts in the past?
No.
So
I mean, we could do. No.
the
but-
only thing is that new requesters would have no way of knowing
Right,
the
but,
AOL
but
was shared.
I'm talking about a very established requester who has been, where this issue has been discussed. So I'm not aware of any other issue with an AOL account other than Mr. Booth's.
Right.
And also I think it has to do with the frequency at which she emails us, which also might be a problematic for, I don't know. I'm not an expert,
Sure.
so that's what I'm
Great.
guessing.
Thanks so much.
Member Pilpil?
So I've got a few questions, but I'll try to keep it brief because I don't think this warrants hours and hours. So let me start with Ms. Patterson. In the future, if we're dealing with a records request from Mr. Bowe or anybody, what's helpful to me as a member of the task force is to get your letter. The screenshot from the, the junk mail box was helpful. It's also helpful to have the original request from the requester, however it came in, email, paper, carrier pigeon, whatever, and your initial response to it. I'm not, frankly,
Sure.
that interested in the substantive stuff. If there's an issue that the complainant raises about the substantive stuff, either the redaction or that stuff was missing or whatever, then sure, it's relevant. But in this case, it was like 50 pages of stuff that I read through, and I was like, is there something here?
Sure.
I didn't find anything. Yes, there was one log thing that Howard didn't sign. I didn't care. That wasn't the issue before us.
Yeah.
It was really
Sure.
the timeliness of the response. So that's just going forward.
Yeah, well, typically we CC Victor on all our responses because it just gets because the volume of requests and the back and forth gets just really confusing. So we've done that in the past. So I'm not sure if we accidentally didn't CC you on that, but typically we do to sort of as an insurance, right? And to help Victor when he's putting the packet together, have all the records because they just get crazy. So
Well,
this is an
but it may
exception, I
give-
would say. Normally we do include all of that.
Okay, but it might also be harder on Victor if he's getting all of that stuff because it won't necessarily have a file number, and to try to pull that. And anyway, we can work in the future on balancing the burdens of how we deal with complaints. But I was just saying in terms of what I was looking at, it was only a couple of things here.
Sure, and typically we do
Okay.
include that.
Okay. The letter didn't indicate what the address is for records requests, so can you remind me?
I think it's like records requests at sfgov.org or SFAC records requests at sfgov.org.
Okay, so in the future it would be good to remind us with that in the letter. But okay.
Sure.
I think Josh got to the right questions about email and filtering and all that. If there's a way, and again, if you could check with your IT people, for any email that comes to anybody at the commission, if it's got the magic words immediate disclosure request in the subject line, if there's a way to filter that, to send to you, to raise the flag, to do something, because those really are the magic words that need special attention, if you will.
Okay.
And yes, someone could make a regular request that doesn't have the magic words. It still needs attention within 10 days.
Sure.
And you should have those flagged too, but that's not going to be as obvious. So
Sure.
anyway, if there's a way to look for that. I mean, unfortunately, I'm leaning towards a violation here because it didn't get responded to and ended up in junk. I don't think that it's like a big deal. I think that you're working, and we've talked about ways to address that. It would be good if Ms. Trabeau, and I will suggest this to her in a moment, sends all records requests to your general records request thing rather than individual staffers. If she wants to copy individual staffers, that's fine too. But it makes it a lot easier if it's all centralized. So you, or in your absence, Rebecca or Ann or whoever, or Sharon or whoever's checking it, and I assume you've got that set up so it's not just you, that others have access to that in your absence, the general address.
Yeah.
Okay. The other thing that is not currently a requirement of the law, but I think is good practice, and I would encourage you to try to do, is when you get an immediate disclosure request, prior to responding to it by the close of business on the following day, if you could send an acknowledgement back to the requester saying, we got this IDR, here's what we understand what you're looking for. If this is wrong, please let us know. We're on it. We intend to respond to you by the end of the day, or some acknowledgement, so if you got it wrong or if they meant something wrong or whatever, that can be fixed. And that if they don't get that in a timely fashion, then they can, have another opportunity to get back to you and say, hey, did you maybe miss this thing? I sent it last night, blah, blah, blah. So it's a practice that you might want to think about. It's not a requirement. And I know that you're doing a lot with the log and other things. We can talk about the request software sometime. But it's just a thing that I'd ask you to think about.
I hear you, and for normal records requests, I always send an acknowledgement, especially when I know if it's not, doesn't require an immediate response within 24 hours. I really do. I feel like the volume of the emails that we get from this particular individual, my goal is to just respond within 24 hours, and I honestly just writing another email acknowledging it, it's already very cumbersome. So I hear you, and I totally think it's a good practice, but I'm just saying I'm not going to be held accountable.
No, I understand. It's a suggestion, and there are other agencies that actually assign a request number to each thing, and so in their acknowledgement or their response, they say, it's not just, your request of X date or a recent request, but they say your request number, 2016-156 or something.
Well, my hope is that we'll move to not an automated system, but like a next request, a more formal platform for processing records requests, and that all requests will be public and responses will be public and published accordingly. So
I don't know. I've got some issues with that, but I hear what you're saying.
Yeah. So, I hope that there's, and that it's, that whatever is adopted is citywide, so that we're not creating special programs for individual agencies.
I totally agree with that. Again,
your suggestions are noted. Thank you.
Okay, and I appreciate that you're willing to engage and take our suggestions. Again, on the particular facts, however, I'm leaning towards a violation because it just didn't get handled on a timely basis. For understanding the reasons, but it didn't. So there's that.
Okay.
To Ms. Trabeau, if you care to comment on that, and in particular on using the general SFAC records request email address, if you could do that in the future.
Well, actually, I did send it to, she doesn't even know what the email address is. It's just listed on their website. There's no directions or anything of that nature. It's just something that's there. So for a new person, they would have no idea even what it is. It doesn't explain anything. There's that. And I originally sent this IDR to the generic thing, copying Kate Patterson. It was the December 1st was a Friday, and it was around around 4 o'clock in the afternoon. It did not kick back to me. It didn't say, go contact somebody else in my absence. It was nothing like that.
Do you have a copy of that email?
No.
Okay.
No, I didn't. So there was also another email that I received, which is Anne had to get it out of the junk file folder because Howard didn't know how to do it. I don't know who is Anne. It just seemed that by filing the formal complaint, it triggered them trying to figure out what's going on. And also I want to say I did notice them that I switched my email address because it's full to capacity with repetitive emails from Kate Patterson. It's near impossible to try and decipher the abundance of emails I get from her.
Okay, well, I'm told that people with email, and as you know, I'm not one of them, have to go through their email box regularly and clear and delete and filter. And
well, I want to say that her claims that we're working on it or we're revising our things are absolutely not true. I sent and I do not bombard these people with IDRs. I sent one yesterday. It did not kick back that the person was out of the office or...
Understood. I don't want to debate and discuss that right this second. But again, in the future, if you could use either their generic address or send it to that with a copy to Howard or and/or Kate, just so they all have it. It's
usually
and to Ms. Patterson, I think it's better if like 3 of you get it rather than just one that could get lost. There's less of a chance that the 3 will all get lost.
But understand that if I were to call Kate Patterson, the normal course of doing things over a period of 3 years is for her to slam down the phone.
Yes, we've heard about that. I understand that.
Okay.
Just trying to get you the stuff. That's all.
Yeah, I appreciate that.
Okay. Ravonna?
Yeah, Mr. Wu, a quick question. The usual question. Despite all the mishigas and the back and forth, did you get everything? Even if it wasn't in complete, total order, which actually is, cumbersome and annoying, but not part of the rules.
The purpose for an immediate disclosure request is that you need the information quickly.
Immediately.
And there was a hearing coming up with this particular individual, and I wanted to see his file. I wanted to see if there were any recent updates so I could be aware. And that hearing was coming up quickly. I think it was that same week. So I did get them, but it would have been better if I got them sooner.
Members, do you have any other discussion or what?
Rebuttals?
I haven't gotten to that yet. Any more discussion before we rebut?
I just have one quick thought, which is sort of going off of what you were saying with the email, is that it may be possible and make sense, and perhaps it's certainly not necessary within the confines of the law, but it may make sense to have the keywords, whether it's in the subject or the body of the email for immediate disclosure request, automatically generate a reply to both the recipient and the sender confirming that it's been sent out, which would then notify that person that this IDR exists, because they too would receive this email, and so it would automatically generate the email and also
like a
service
high priority and a red flag. And
exactly.
Yeah, but that's a whole other system. I mean, we're all... I'm sorry, were you done? I'm just talking. Wait, I'm the chair. I can do whatever I want. Thank you, Member Wolf.
I was just bouncing off of what David was suggesting.
Yeah. And if there's a way to do it...
Well, I'm going to cut both of you off because, as Ms. Patterson-Murphy said, this is what I do for a living. And I'm sure we've all been there. You've put something in for customer service or something for some other organization, and you immediately get an email response saying, this is DirecTV. We've received your inquiry. Someone will get back to you within 24 to 48 hours. Ms. Patterson-Murphy, I don't really know how the technology system of San Francisco works. If you wanted something like that, would you have to put in the equivalent of like a purchase order or a work order with DTIS or whatever they're called now to get something? Yeah, I know. It's, yeah. Because you do that manually, right? If somebody sends you an email and you get it and it doesn't go to junk, and it takes you a day or two, and it's to get the information, do you manually write back and say, Dear Lou Fisher, I saw your email, we'll get back to you when I can, or?
I mean, generally, yes. I mean, not for immediate disclosure requests,
Yeah.
because my goal is to just get them the information and respond within the window. But I feel like last time when this came up, there was some issue with the city inboxes and automatic replies. I feel like this came up, so I don't remember what
remember
it
this.
was, but there was something
It was
like,
when you were on maternity.
or I just don't remember, but I feel like there was some issue with automatic replies, or there was something that was like crashing city emails. I could be conflating two things, but that seems to ring a bell for me. I don't remember exactly.
But you'll check with DT, and that's good.
Yeah, I mean, at the very least, I'll make sure to filter the emails, so immediate disclosure emails are always delivered to the inbox versus junk mail. So yeah, I mean, I think that's something that we can even do internally, just by setting rules in Outlook. So that's fine.
Great.
So I'm going to wrap this up with, what? I mean, 4 or 5 years ago, when Member Pilpel and I started, I mean, we basically made our bones on the Arts Commission because, with all due respect, Ms. Patterson-Murphy, you guys were a mess 5 years ago. Agendas never got posted. You were so backed up. Sunshine came along and did what we were supposed to do, shined a light on it, and I hope brought some more resources to your organization. David, you would know. What's the name of the other woman and the other who shows up
Ms.
here all the
Paige
time?
Ritchie?
Yes, Ms. Paige Ritchie was able to hire interns and bring people in. And since then, it's gone pretty smoothly. Things are a lot better. I mean, we're getting there. Ms. Trabou, yeah, this was a bit of a bummer. And I understand where you're coming from on this. I don't really see any violation unless my colleagues do.
Why don't we have rebuttals, and then we can see if there's a motion?
That sounds like a good idea.
Oh, did I already skip ahead?
Yes.
Oops. Why don't we have rebuttals? We start with the respondent first, right?
I don't really have anything else to add. I will say that December 1st was not a Friday, it was a Tuesday. That's all I have to add in terms of rebuttals.
Just history.
Come on, Mr. Trabou, sorry. You have how many minutes?
3.
Okay, so nothing really has changed. If we're going to look at this complaint today and look at this morning, we're going to see that a certain person was out of the office. That's what the voicemail said. But when I sent an email, nothing kicked back that the person was out of the office or gone. I don't leave messages because I'm afraid that I'm going to be accused of harassing these people. I would never get a return phone call anyway. So there's that. Nothing really has changed. This is not by any way an isolated incident. I had nothing kicked back this morning when I sent an email. So you send it out there and you're kind of left wondering, well, is something going to come back? I don't know. I really don't understand. So you wait, and then you try to figure it out. This is not an isolated incident. It's pretty clear that Howard Lazar doesn't even know how to get something out of a trash mailbox. So once again, if this complaint hadn't been filed, that I wouldn't have gotten a response ever. So once again, she's lying. I don't bombard them with emails. I don't... they were a mess years ago. Well, they're still a mess now. If you want to talk about things, their audio is still a mess. It's incomprehensible, but that's off topic. It's still the same thing. Nothing really has changed. This was filed on December 1st, and I got the paperwork almost 2 weeks later. Way late, way after I needed it. I mean, I don't call. I don't need to send them alerts or reminders or anything of that nature. So no, in my view, nothing has changed. It's a violation of 6725A.
25A?
Are we done with that?
Yeah. Did you have something, Member Pilpel? Would you like to be recognized?
Thank you.
Member Pilpel.
Thank you. Yeah, I mean, I think we've had good discussion. I'm not sure that this would need a follow-up, but I am kind of feeling a 67.25A violation. I don't think it's not the biggest deal, but I think it was not responded to on a timely basis. It was brought to our attention. they've taken, some steps to try to avoid this in the future, which are good.
What did you say, 25A?
Yeah. On page 5 of the packet is the text there.
So I could just look it up right there, too. It said page 5.
Yeah.
Member
So
Wolf, do you have anything to add?
No, that sounds good to me.
you want to second my motion?
I'll second.
Okay.
Is that page 5 of the packet?
Is there any public comment on the motion to find a violation of 67.25A? There being no members of the public present at this time. On that motion,
Well, could we, wait a sec, I would
Yeah.
like to read. I'm
hold on.
25A.
And I don't think we needed this in the recommendation, but the suggestion is that there doesn't need to be a referral if the violation is found by the full task force.
So, Mr. Young, if I'm willing to go along with this, do I have to add
no,
add
just
something to
all you
the,
need to do is vote no on the matter.
and then if I want to add a recommendation as chair to the, when this goes to the full body,
I'd be happy to add that in
Okay.
to the recommendation.
okay.
On that motion, Member Wolf.
Aye.
Wolf, aye. Member Pilpil.
Aye.
Pilpil, aye. Chair Fisher.
Aye.
Fisher, aye. Is there any notes you would like me to add to the recommendation?
Yeah, when this goes to the recommendation, to the full task force, just make a note that we don't really see any need for any additional follow-up to this. We just wanted to get it in the record, and Ms. Patterson
And maybe we
will
can-
communicate to Mr. Lazar that, this happened, and now they know
And maybe we
to
could
watch
also
for it.
memorialize that they're going to check with their IT and DT, and we appreciate the.
Yeah, that's it's implied.
Well, no, I think we want to appreciate the work of the Arts Commission to try
Okay,
to fix this.
write the words IT in there then.
Yeah.
Thank you. Next on the agenda, item number 3.
And this is likely for June, it's not going to be next
Yeah,
week.
this won't be May, right?
It will not be May.
Yeah, okay. Thank you.
Item number 3, file number 16033, complaint filed by Andrew Bowe against Sharon Page Ritchie and the Arts Commission for allegedly violating Administrative Code Section 67.16 by failing to make draft minutes available for inspection no later than 10 working days after the meeting.
Okay, so.
Move to find jurisdiction?
Yeah. Second.
There are no members of the public to comment on jurisdiction at this time. On that motion, Member Wolf?
Without
Aye.
without objection?
Motion
Yeah,
passes
without
without objection.
Thank you anyhow for being on that.
Would the complainant like to make their presentation?
All right, 5 minutes.
I am referring to page 81 of your packet, which was an email that I sent to the Commission Secretary, Sharon Page Ritchie, on the 31st of March at night. I was asking to inspect the draft minutes of the March 7th meeting. Please contact me to arrange a date and time. She didn't contact me. So, according to the Sunshine Ordinance, if someone wants to inspect draft minutes, they should contact you to arrange a date and time to inspect the minutes. There was no offer of that. I think I may have called once or twice, and no one ever picks up the phone there. So that's what triggered this complaint. And then what came back on March 31st from Sharon Page Ritchie is that they've been posted. Well, that didn't respond to me wanting to inspect the minutes. So that's why I filed this complaint. On March 7th, I did send a follow-up email. On the 21st, asking again. I haven't heard from you. Kind of ask, when do you intend on posting these draft minutes? Once again, I didn't get a response, just a link to the thing. So basically, I was monitoring these minutes to see when they would be up, and curiously enough, they went down for 4 days. Probably about 2 weeks ago, which is the subject of yet another Sunshine complaint. I checked, and they just weren't there. So that was well after the 10 business day window. So my contention is I asked to inspect the minutes. I did not get a response, and eventually I got a link saying that the minutes have posted. So I didn't think that was cool at all. And I did copy other people, so there was no issue about that. And it's very difficult to put the burden on a member of the public to be counting out 10 business days, knowing with the history that the Arts Commission has, posting them on the 10th business day at 6 at night, at midnight, at 11 at night, and particularly when it's a weekend, it is frazzling. And when you don't get a response, it's a little bit difficult. So that's my issue is she didn't respond to my request to inspect the draft minutes. That's it.
Okay. Normally, I would ask for anyone to offer facts and evidence, but there is no one in the gallery, so we will now hear from the respondent from the Arts Commission.
Kate Patterson, Arts Commission. So I'm just looking through the email correspondence, and as we stated in the letter, the first email we received requesting to see the minutes, which was on Sunday, March 20th, and then we also received something requesting the same thing on March 21st, which is the very next day. And March 21st also happened to be the 10-day business due date for the minutes. So as far as I know, all I have is this email. I don't know what the previous request was in that window between the meeting and the March 20th request. And when we responded the next business day, we actually had the draft minutes. So we just sent the draft minutes. So I do have an email that Ms. Trabou sent to Victor and Angela on March 18th, but we're not CC'd on that, so I don't quite understand that. And then I can see just above that then is the email that we received on Sunday the 20th. So I'm not sure how we didn't respond to a request to review the draft minutes before then, because we did respond the very same day we received the request with the draft minutes. So unless I'm missing something, I think we did what we were supposed to do.
Member Pilpel?
Thank you. I hope and think that this will go even faster than the last one. I'm not feeling anything here. The 10th business day after March 7th was March 21st. The March 18th was the 9th business day. The draft minutes should have been made available by the close of business on Monday, March 21st. It appears that they were. And we've discussed this before, just in the future, I would prefer if they were posted before 5 p.m. I mean, the email was sent at 5:08 saying that they had been posted, so it's not clear when, but presumably before then. But it's just good to do it before 5 p.m. on that day. Sooner is obviously better. They can be a first draft. They can be changed later. But it appears that the draft minutes were available by the close of business on the 10th business day. So I'm not finding a thing here. I appreciate that the email did go to several people, so it wasn't an issue of getting stuck in a box somewhere. I haven't heard that there was some other extenuating circumstance or some reason to get them sooner. So I'm not seeing a problem on this one.
Thank you, Member Pilpel. Member Wolf?
Have any questions?
I don't have anything either. Oh, rebuttals. Thank you. So now let's move to rebuttals. The Arts Commission, the respondent goes first, right? The Arts Commission is nodding her head and waiving her right to rebut. Ms. Trabou, you have 3 minutes.
Can I bring it up? I don't know how to do it on this thing. To find out when If I can say,
Mr.
just-
Young, can you, oh, go ahead.
if you don't mind, I don't know how to do it.
Victor, can you help her? If it's
My issue
evidence,
is-
if it's helpful.
You keep advising them over and over again. It would be good to post them a little bit sooner, before 5 o'clock. Okay, well, what happens when they go down for 4 days after they've been posted? What happens then? They're not
before us.
up.
Not before us today.
It just kind of leaves you always hanging. What is going on with these people? Because you make the same suggestions over and over again, and they say, yeah, we're going to do it, and they don't.
I think it's sfartscommission.org.
Yeah.
There, for example.
Oh, have we started the clock?
No.
Tell me when.
You might want to close that thing on the bottom in the yellow box. Somebody help her.
Pull it up on my phone. My objection is just the way they do things. I mean, she could have responded and said, no, I'm not going to let you inspect the draft minutes. There could have been some response there.
Presumably at this point, the draft minutes would have been replaced by the final adopted minutes, so I'm not sure if we're going to find evidence on here of when the draft minutes were posted. Is that correct?
There's usually not an indication of what time. There's usually not an indication of what time they're actually.
Right.
They do post it on the bottom of their agendas.
Okay,
what time
so
they're posted.
I'm looking at the May 7th full commission meeting, revised draft minutes.
We're on the March 7th meeting. That's the issue before us.
March 7th.
You
Yeah.
said May.
I'm sorry, March 7th, meeting of the Full Arts Commission, revised draft minutes.
Okay. Let's see if
Okay.
we can pull something up here.
Okay, so at the bottom, posted 3/21/16 at 5 p.m. SPR, I guess that's Sharon Page Ritchie, revised 4/1/16 at 8 p.m. There was this window of 4 days where prior or after March 21st, there were no minutes at all.
Okay, so.
But that's not the subject of this complaint.
Okay, so what it looks like here, and Ms. Patterson, if you want to just check it, says posted 3/21/16 at 5 p.m.
Well, because
SPR.
they have to be approved by the full commission.
Right, but hold
So,
on.
I mean,
Hold
it's
on.
not that, and they don't come down in that interim time.
Hold on. So it says posted 3/21/16 at 5 p.m. Sharon Page Ritchie. So the requirement was that it be posted by close of business on 3/21. So this seems to be evidence of compliance. Am I missing something? Okay.
Yeah.
So maybe we can finish our rebuttals and move on.
I
Have
think we're
anything
ready to
further?
hear Ms. Trabou's, are we ready to hear Ms. Trabou's rebuttal, or did we start
Do you
yet?
have anything additional?
Oh, that was the rebuttal. Okay. I can't see the clock, so I don't, is the time up?
There's 1 minute and 9 seconds
Okay.
left in the rebuttal.
Okay.
Do you have anything additional to state?
Hear it.
She has another minute. That's her time. She can do what she wants with it.
Okay, once again, there's no consistency into how they post and revise their complaints. I'm referring to the full commission meeting that took place the month prior And down at the bottom are different notations. It posted on 2/15 at 7:30 p.m., but were approved, not revised, approved on 3/7/16. So what's going on with these people? Maybe this isn't a violation, it's just another one of those procedural things that they need to get together. This commission secretary has had this same job for more than a decade. You would think that there would be some consistency. It doesn't appear that there is. And what happens with the next complaint coming up where the minutes were just gone for 4 days? How are they going to prove that? Or what's the response going to be? There's just no consistency in how they do things. And this is the same person posting these same minutes. It's not different individuals in a subcommittee.
Thank you.
So back to the committee.
Let's bring it back to the task force.
So the only set of minutes that's at issue here is the March 7th meeting. I've said a couple of times it appears that was in compliance. I'm a big fan of consistency, but the question of consistency really isn't before us. And so I'm just not feeling that there's a problem on this. It appears that it was made available on a timely basis. I'm good, and I would recommend that we find no violation. Do we need a motion to make that recommendation?
Yes, it's moved to refer
Yeah.
to the task force with the recommendation that no violation
Oh,
occurred.
so there is, because I know in the full meetings, we just move on.
Yeah.
I'll second David's.
Yeah, what he said. I think we can probably, go ahead, call the roll.
So it's a motion to recommend that the task force find no violation.
Correct.
There being no members of the public in the room in that time, on the motion, Member Wolf.
Aye.
Wolf, aye. Member Pilpil.
Aye.
Pilpil, aye. Chair Fisher.
Aye.
Fisher, aye. The motion passes. Next on the agenda is item number 4.
Thank you.
Thank you.
File number 16018, complaint filed by Charles Pitts against Sheriff Vicky Hennessy and the Sheriff's Department for allegedly violating Administrative Code Section 67.25 by failing to respond to immediate disclosure requests in a timely and/or complete manner.
What do we do when the complainant is not present?
Usually we would,
Continue it? or-
no, we would table the matter and so inform the complainant that the matter has been tabled due to their non-appearance. But if you would like to hear anything from the Sheriff's Department, as long as they are here,
Yes, two things, though, two questions for you. One, what does tabling really mean? It means it goes away and they have to refile, or?
they would have to respond to me, either refile or request that the file be reopened,
Okay.
which in effect is the same thing.
All right, the other alternative is that I, as the chair, move it to another meeting, but I don't see the need to
I
do
believe our
that.
standard is to table the matter when
Yeah.
they do not appear without prior notice.
Yeah.
I'm going for that, but also, since we have Ms. Horn and Mr. Mark, whose last name I can't
Mr.
remember.
Nico.
Mr. Nico, maybe they could give us 3 or 4 minutes, tell us a little bit about their side of this. Is that okay?
That's fine.
Okay.
Okay.
Because I actually have a really specific question, so I'd like to at least hear. But Member Wolf, you went like this, so.
I mean, I think that we should either not hear from the Sheriff's Department, or we should hear from the Sheriff's Department in a necessary move in Pitt's absence around what we recommend for the case. But I think that if we're opening it, like, we have the merits of the case, we have what Mr. Pitts wrote down and said and what's been submitted. So I don't know why we're hearing from the Sheriff's Department unless we're going to take what we have on paper and apply it to whether or not to what recommendation to move forward to the full task force.
I understand what you're saying, but I would think.
You are allowed to do that.
Historical precedence shows that we don't really do that, right? And I really,
We've done all kinds of
I want to hear what
different
Mr.
things.
Young
It has not
has.
come up in quite a while, but
But I've been here a long time. What did we do the last 2 times? We tabled it. I don't.
We do table it if the complainant doesn't appear without prior notice.
Yeah.
Yeah, I
It's-
really don't want to. I understand.
I'm not opposed to tabling it. I have concerns about tabling it and then hearing from the responding party.
Noted. Member Pilpel?
I think that we can table for all the reasons that were discussed. I think since Mr. Nico and Ms. Horn are here, if we have a couple of quick questions related to the thing that might help explain something about something, I don't see any harm in asking that.
And I'm
So why
coming
don't we-
from a courtesy standpoint. I mean, Mr. Nico has been here for 55 minutes. I'd at least like to give him 2 or 3 minutes, because he's...
And I actually had a couple of questions as well, and
They're
that
going to
would
be
probably-
short.
Yeah.
And if we do table this, it's going to come back, and then Mr. Nico will come and say the same things again,
If Mr. Pitts chooses to reopen.
if he comes back. Yeah. Does that sound right, Mr. Young? So
Yes.
how do we do this now? Do we just call the item, or?
We did call it. Did
Called
we call
it.
the item?
I have called the item.
Okay, so
Okay.
then you just ask. You ask whatever you want.
Come on up. He's here.
Mark Nico, on behalf of the Sheriff's Department, I do want to say I agree with Member Wolf's perspective of this.
So do I.
If it's not going to be heard and decided, it really doesn't help at this point for the sheriff to give its information. On the other hand, if there is something about this case that you could, informally, I could discuss what the issues were. So for this case or other cases, if something's going on that we could address, I'm happy to do that. But that's sort of how I see
Yeah,
it.
I had actually 2. Can we just ask now?
Yeah, do it.
I have a question. Somewhere in there, I wrote this down. I always get confused between sheriff and PD. So who has this video right now? Is it with the sheriff's department, or is it with SFPD?
My understanding from the request is it was a detention or arrest at City Hall. Therefore, City Hall management runs the video. It's sort of part of City Hall. However, the Sheriff's Department, as security at City Hall, maintains it.
Okay.
So the request does come to us for that video.
Are you police or sheriff?
Sheriff.
You're sheriff, too. I know
Correct.
Ms. Horn is sheriff. Okay.
Sheriff.
And so as I read, the video itself, if I were detained and I wanted a copy of the video, it's part of the case, and so I would not be able to see it? Is that?
You would not be able to get it by a public records request, by court order or subpoena, or a law enforcement investigation into that incident would be able to obtain it.
Member Pilpil?
Yeah, thank you.
Confusing to me.
And I don't want to really inquire about Mr. Pitts or the instant request, because I think we're not dealing with that right now. But I was intrigued by the question of the video and wanted to explore that a little more. So in any public request that you get for a video, you would maintain the same position that video taken at City Hall is not subject to disclosure, and you didn't have a specific citation, but I think, was it 6254F?
F.
Okay.
I did. I'm not sure if I put it
Somewhere.
in my response to you, but to Mr.
Right.
Pitts, I did.
Yeah, you did. Okay. And so help me understand. We've been before with Mr. Garza at SF General with video questions, and there was video taken at SF General that ultimately was provided, and blah, blah, blah. Does the sheriff have a somewhat similar, though not exactly the same, responsibility for video and control and whatnot at SF General and City Hall, or are they totally different? Help me there.
City Hall, Civic Center Courthouse, SF General in general.
Right.
Hall of Justice, jails, San Bruno Jail,
Right.
Other sheriff's facilities like that.
Okay, but does the sheriff operate the video systems or have control of the video at all of those facilities in the same way? So the reason I ask is that when he asked for video at SF General, that was provided, and so what's the difference in your handling of a video camera at SF General versus a camera here?
I haven't dealt with San Francisco General. However, City Hall is a little bit different because City Hall, the video is actually City Hall management
Okay.
run and owned. We're security, so we control it.
Okay.
For purposes of dissemination and things like that, it's the Sheriff's Department who makes that decision and who maintains the confidentiality of that. San Francisco, and same with Hall of Justice, same with
Okay.
Civic Center Courthouse. San Francisco General, I can only tell you that,
You've got
looking
a
at the whole
contract
picture,
and
it
it's
would
a
be the same thing,
relationship.
maybe you've had other experiences with that.
You know, I may be incorrect about this in the Garza case, but I believe, Freya Horn, by the way, from the Sheriff's Department, I believe
Welcome back.
that decision is made, it's DPH, Department of Public Health, and I believe the decision to release whatever was released there was made by the Department of Public Health.
Okay, so I don't want to get into the issue of whether it's DPH and if you've got a contract with them and if it's City Hall Building Management and who actually owns the video and who's the custodian and who makes the decision. I'm just trying to understand better why you would treat video at City Hall differently and consider that exempt under 6254F as opposed to video at other facilities. I just wanted to understand the basis there, if you could just help me.
Yeah, and I don't, all I can tell you is that historically, as far as I know, and I think the issue has come before this group
It has.
in the past, and that I'm not sure the two are treated the same. The security, the videotape for the areas that we cover is considered security video, and I don't know if that includes San Francisco General because it's maintained, I believe that it's maintained by the Department of Public Health and that they may have a different standard, and I don't want you to hold me to that.
No, I understand.
I believe that they may have a different standard, but the video for City Hall, the jails, the courts, it's considered security video and it's exempt under 6254F, except by court order, subpoena, or for criminal investigations, is my understanding.
Member Pilpel, Member Wolf has something to ask.
Do that and then I'll come back.
Member Wolf.
So I'm just trying to get an understanding of what type of video we're talking about. So are we talking about body cam mounted cameras owned by the personnel? We're talking about surveillance mounted cameras on the walls.
Correct.
Are those cameras in an area that is not publicly accessible?
Good question.
I don't know, personally, I don't know where every camera is. I know there are cameras in publicly accessible areas, and there certainly are in none also.
I know where the cameras are. That's not the question, Dave.
I would say both.
So, but Mr. Pitts was only in a certain portion. Mr. Pitts was only captured on a certain portion of the cameras. Cameras that weren't where he was aren't part of this request. So was Mr. Pitts captured on camera in areas that are not publicly accessible?
I've not seen the video with Mr. Pitts. I would assume that he was in public places.
So if someone requests access to the footage not related to a sheriff's incident, say the security cameras in City Hall, a really clever wedding videographer decides, let's add those, and files a public records request, would they be turned over? Would they be considered investigatory?
Still security video. The purpose of the video is security for this building. You can't just have the video maintained and then give it out to the public on a daily basis, whoever wants it. It doesn't matter who's requesting it. As long as if there's a public records request, whether it's Mr. Pitts on his own incident or a wedding on another day, it doesn't matter. There's still security video. You would still need a court order, a subpoena, or a law enforcement investigation to get a copy of it.
So this is the thing that I'm particularly interested in. I appreciate that we're having some discussion about it. I don't want to drone on too long. I guess I'm just still interested in how 6254F would apply to that kind of video, and if it's different because the sheriff is involved as opposed to another department. Because I'm aware that other city departments have security cameras and have video, whether it's a public safety department like yours with jails and facilities, or adult or not adult, but juvenile probation at their facility, or things like MTA in subway stations and bus yards, or rec park at rec facilities, or PUC at water treatment facilities, et cetera. And I'm just trying to understand what cameras and what video records the city makes or keeps would be subject to disclosure because they're just public records, they're videos, or wouldn't be because they're exempt under 6254F and how that applies. I just think it's an interesting question.
I think we're probably going to be revisiting this, so.
Well, I don't know that we will, and we have gotten complaints before, and I think Ms. Horn is correct. People who have asked for video for the camera outside the mayor's office, for example, and I think where the department can, or either the...
You might be going beyond what's listed on the
I know, but
Yeah,
we're almost done
I
here.
gave him this much leeway, and I'm
Well,
about
hold
to
on.
close it off.
I'm just trying to finish here, that where the mayor or the sheriff or someone else can articulate an actual security concern with releasing the video because it might explain the pattern of traffic or angles or something, I think there's a heightened sensitivity and a good basis for non-disclosure. But absent some sort of showing, I think that, the wedding video that doesn't show anybody else but is just a wedding video on a Saturday or a Thursday afternoon or something might be subject to disclosure. And so I wanted to tease that out a little bit. Maybe we can all just think about this a little more. I don't know that we need to reach any conclusion today on this.
Yeah, I don't think they came here to discuss that.
I
We've
think
got-
this is a good chit-chat.
Okay,
though.
let's let your colleague have something. Then
So
we'll-
now that we've opened the door, which was the door
It's
that I
now
was,
Pandora's box.
which I
but,
was
yeah.
not wanting to open, I don't really, I see concerns with the sheriff's department's interpretation of 6254F in the way that I've read it. We haven't done this before because Mr. Pitts isn't here, but we've now created the situation where I feel there's this disjunct, and I would like to make a motion to move this to the full task force with no recommendation from this committee.
And have a subsequent hearing?
And have a hearing on these issues, assuming that Mr. Pitts, who is likely over at the hunger strike right now, which is where he's been since it began, would attend that hearing.
I see where you're going on
The motion has
that.
been made. Is there a second?
I would like to hear the motion as it's written, because I'm not
The motion
sure
is to move that this matter be referred to the task force without recommendation for a hearing before the task force.
Yeah, we've set up this subcommittee for a reason, and while I see where you're going on this, but I could kind of go that way. For now, let's keep it with this complaint committee or whatever we're called and see if Mr. Pitts refiles this. But you're welcome to make that motion, and clearly Member Pilpel is going to be the deciding vote here.
Is there a second on that motion?
I'm thinking not at this point,
Okay.
and I can explain. The request,
feelings.
the complaint that we actually got from Mr. Pitts, as I'm reading it, is refused to provide information requested, refused to respond to 67.25A, refused to stamp as received police report. I don't know. And he does have a date here of January 22nd. You were suggesting that there was no date. His thing actually says January 22nd. I don't know how he provided it. He didn't explain. We don't know. But I think his issue was on just failure to receive and respond to
Yeah, this
his
is an
request.
IDR.
However, he thinks it got to you, or maybe it did, maybe it didn't.
Yeah, this is
I don't
an
think he-
IDR.
Right. I don't think he was raising the issue of non-disclosure of the video as being germane right this moment. We may think it matters, but
If
I'm
I
not sure that he is.
If I can kind of, I feel like, wow, I could just push this play button in my head because I've said this so many times in my 4 years on this body. I mean, I'm looking at this, and file number 16018 is purely a 67.25 for an IDR failing to respond, and I'm going through 7 other doors on the end of this. I'm really kind of concerned about this whole video thing, but that's not what the complaint is, and that's not what was brought in front of us. I'm just looking, I often say the expression, I wish I was queen for a day and can fix everything, like the time my car got broken into right across from City Hall. And then DA Kamala Harris would not release the video to me, even though I had a police report. And I was like, really, DA Harris? Great. So, but I'm just looking at 16018 is an IDR 6725, and I don't see anything.
Wait.
Yes.
Sorry to keep raising my hand like that when there's 3 of us, but
Well, that's what you do. It's fine.
it says refused to provide information requested. It happened to be an IDR, but he requested information that he hasn't received. His complaint is that they refused to provide the information requested. I think what you're trying to get at, David, is that because he put the date next to it, that essentially reading into the subtext of his complaint is the IDR component in there. But now we're interpreting his complaint. But I have the reason I have concerns about not moving this forward is that the sheriff's department has essentially said that all of the surveillance cameras are non-disclosable under Public Records Act. Other jurisdictions in other locales have identified this, I believe, as the same thing as ongoing investigation material. There's numerous cases where what would be security footage that belonged to the city has been turned over. So I find some serious disjuncts in here that do feel like they're worth revisiting in front of the full task force.
And if I may, I don't disagree. I think that there are some, what do we say, colorable issues here. But we don't have Mr. Pitts. If he wants to reactivate this file, then I don't think it would go back to a committee. I think we would just bring it to the full task force on the merits. We don't know. I'm presuming from his statement that he tried to get something to the sheriff on January 22nd. We have no idea how. Presumably this is the request. And what's before us is that the sheriff's department, once they were alerted to it and made aware that there was a request, responded on the same day with the incident report and with an explanation for why they couldn't provide the video. So I'm pretty satisfied that the sheriff's department, when notified, made the records available. If I'm wrong, and if he wants to bring additional evidence or explain that, he came by and was waving and they wouldn't take the thing and that was a big deal, we should hear that if and when he lets us know. Sure. But with what's before us now, I think we table the matter because he didn't appear.
And, we're all sitting here trying to get into a very dangerous place, which is anybody else's head. So maybe Mr. Pitts has decided not to pursue this. Maybe something has changed. Who knows? So I think we should just thank the representatives from the sheriff's department for
we may be back on this on the merits someday.
And if Mr. Pitts brings it back, I would suggest to Mr. Young that you just put it in front of the whole task force.
At this time, is there a second for Member Wolf's motion?
There's no second on that. Do you want a motion?
Is there an additional motion?
How about a motion to table?
Second.
Is there any public comment on the motion to table the matter due to non-appearance of the complainant?
That's you, Ms. Trabou. Any public comment? Yeah. You're actually allowed to comment on this.
Charles Pitts spends a lot of time in the law library on Market Street. I know I see him there. So he certainly was around. He certainly was aware of this complaint. I don't talk to him, but if you say that he was doing a hunger strike close by, he certainly could have called or done something. Instead, people are inconvenienced and we're trying to understand what his intention was. He could have called.
Okay, thank you, everyone.
We're about to vote, but again, to Mark and Freya,
They don't care.
in the event that we do get to this on the merits at some point, obviously you'll hear about it. If you can just be sensitive to that 6254F question and be able to address it. Thank you very much. Keep up the good work. Thanks.
On that motion to table the matter, Member Wolf?
No.
Wolf, no. Member Pilpil?
Aye.
Pilpil, aye. Chair Fisher?
Aye.
Fisher, aye. The motion passes. Item number 5, public comment. Members of the public may address the complaint committee on matters that are within the committee's jurisdiction but not on today's agenda.
Oh, can anybody do that? Okay.
General public comment, right?
General public comment.
I know.
Hi. I have an issue with what you might call the face sheet. That's when somebody comes in and fills out the initial sunshine complaint form, because not much is required. Just basically a free email account will trigger a complaint, and I think that's a real problem. If you look at the previous one, Charles Pitts didn't provide too much information there. okay, I get it, he's homeless or whatever, but as you know, I had an issue with Thomas Piccirillo, who I believe did that maliciously, and he's actually in the law library too, counseling people there as a disbarred lawyer. And I think, it's a public library, people can come in, but if you were to require a bit more information, I think you would make it a little more difficult for people, so they just don't file complaints on the heat of the moment, like Mike Adario, who dropped out at the last second. It takes time, it creates paperwork, and if people are not committed, you're going to see it because they file these weird face sheet complaint things, and it's kind of doomed from the beginning.
There being no other public comment. Item 6, announcements, comments, questions, and future agenda items.
Just two quick things. The complaints that we had today, the two complaints from Mr. Bowe appear to have been, well, one was from the end of last year and one was more recent. The Charles Pitts complaint was relatively recent. I would just hope that with the new appointments and other changes to the task force that we would try to handle complaints sooner. I mean, I think a couple of these we could have done like last month. I know that we were backed up and blah, 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 but I'm concerned about our workload, caseload, and trying to have things not age as much.
Okay.
And the other comment I would make, I made a brief remark last night at the beginning of the Ethics Commission meeting, and I believe that the Board of Supervisors had a commendation action this afternoon. Carla Johnson, who you may or may not know as the director of the Mayor's Office on Disability, apparently is gravely ill, and she's just a wonderful person. Did I talk to you about this? Anyway, it's my last one. Yeah. Anyway, so I just wanted to
remember.
Acknowledge her great work for the city over the years, and perhaps we can adjourn the meeting in her honor since she is still with us. But I hope her the best. Carla Johnson.
Okay.
Thank you.
Do we have anything else?
There being no additional business, would the chair like to adjourn the meeting?
Yeah. Per Member Pilpel, I would like to adjourn the meeting in honor of Carla
Johnson.
Carla Johnson, and we wish her well, and that she get well soon.